Hello, and how are you guys doing? Hope everyone is doing great. For today's video presentation, we like to discuss on the Prima Facie case and evidence. Hope you guys enjoy with our video. In this video, we're gonna discuss on what is means by Prima Facie case, how the Prima Facie is developed, and finally requirement need to be proved in Prima Facie case based on the laws and cases in Malaysia jurisdiction. What does it means by Prima Facie case and evidence law? Prima facie essentially translated from Latin words means case at the first sight. Prima facie may be used as an adjective meaning sufficient to establish a fact or raise a presumption unless disproved or rebutted. Prima facie evidence is the establishment of a legally required rebuttable presumption. A party with a presumption of proof presents a prima facie argument when the party offers ample evidence to justify a decision in the party's favor, if the opponent does not deny or disprove. This implies that the party with a presumption of proof has demonstrated that it can meet the presumption as regards every aspect of its case. How prima facie is developed in Malaysia throughout our past history of jurisdiction. Since Malaysia does not define the word prima facie in any act including the Criminal Procedure Code, judges usually define prima facie according to the dictionary. According to the legal dictionary, prima facie means the first appearance, on his face, based on the first impression, and a prima facie case is a case where evidence in favor of the party is sufficient to demand an answer from its opponent. The developmental history of the level of proof needed to establish a prima facie case can be divided into three parts. The first part is before the Hatu Atal v Public Prosecutor case. The second part is in the case of Hatu Atal v Public Prosecutor. The third part is after the Hatu Atal v Public Prosecutor. Before the case of Hatu Atal, Malaysia court applies the degree of proof as maximum evaluation to establish a prima facie case at the close of prosecution's case. However, once the case of Hatu Atal inserted the concept of minimum evaluation to establish a prima facie at the close of prosecution's case, Malaysia court was undecided to determine which degree of proof should be required to establish a prima facie case at the close of prosecution's case. In the year of 1981, this question has been discussed in the case of Hatu Atal v Public Prosecutor. In Hatu Atal case, the judge mentioned that once defense is called but the accused elects to remain silent and offers no evidence, the judge should do the second time evaluation on the evidence is adduced at the end of the trial before the judge can convict the accused, although the accused elects to remain silent and offers no evidence. In the year of 1997, this question is discussed again in the case of Errol Pragasan Al Sandaraju v Public Prosecutor. In Errol Pragasan Al Sandaraju v Public Prosecutor, the dissenting judgment mentioned that the trial is accorded to natural justice principle. The judge cannot make maximum evaluation at the close of prosecution's case and convict him if the accused remains silent and offers no evidence in the middle of the case. The federal court judge decided the maximum evaluation should be applied and the degree of proof required to establish a prima facie case should be beyond a reasonable doubt at the close of prosecution case. In 2003, the case is Loy Kauchai v Public Prosecutor. The judge has made decision if the accused being called upon the accused defendant elects to remain silent, and if the answer is negative, no prima facie case will be made out. In the 2009, Ahmad Najib v Public Prosecutor, the judge if the accused remain silent and find there is no choice but to convict the accused if the accused failed to rebut the evidence adduced by the prosecution. What is defined as standard of proof in prima facie case? Burden of proof exists when a person is bound to prove the existence or non-existence of any fact. Burden of proof can be defined as the obligation which is imposed on a party to adduce sufficient evidence in support of his contention or fact. In case of Lechaman and Chedir Alagapan Atal Alagapan and Amp, a Norvi Secure Plantation SDNBHD, burden of proof has two distinct meanings in the law of evidence, namely burden of establishing a case as a matter of law in pleadings as stated in Section 101 of Evidence Act 1950 and the burden of introducing evidence in support of its case or defense as in Section 102 of Evidence Act 1950. Position on standard of proof. Two standards of proof was provided including minimum and maximum standard. Minimum evaluation required evidence which was not inherently incredible to prove the essential elements of the charge. If defense was called but the accused remained silent, the court could convict the accused. Meanwhile, under the maximum evaluation approach, the prosecution had to prove the charge beyond reasonable doubt. In Hatu Atal case, court must be satisfied that the prosecution have proven their case beyond reasonable doubt. The court at the end of the prosecution case had a duty to assess whether the evidence tendered by the prosecution is of such quantity and quality that if the accused does not rebut it, he must be convicted. At the end of prosecution case, if the court finds that no case against the accused has been made out if unrebutted would warrant his conviction, the court would acquit the accused. Court must act on the presumptions that all such evidence of primary fact is true, unless it is inherently incredible that no reasonable person would accept it as being true, and that there will be nothing to displace those inferences as to further facts or to the state of mind of the accused which would reasonably be drawn from the primary facts in the absence of any further explanation. At the conclusion of the prosecution's case, what had to be decided remains a question of law only. In the case of Errol Pragasan Al Sandaraju v PP, majority held that the standard of proof required from the prosecution at the close of the prosecution case is not prima facie but proof beyond reasonable doubt. In PP v Muhammad A.S. Abdullah, court shall examine the evidence of the prosecution rigorously and held that the standard to be applied on the evidence was on maximum evaluation test. In Balachandran v PP, prima facie case is a case which is sufficiently strong for the opponent to be called on to answer it and that it can only be overthrown by rebutting evidence. Thus, the court must evaluate the credibility of the evidence to determine that the elements have been established. How case places a lighter burden or what is often called as minimum evaluation test at the end of the prosecution stage, though it maintains maximum evaluation test at the end of the defense case. However, the jurisprudence and law is to maintain maximum evaluation test at the end of the prosecution stage as well as defense stage as advocated in the case of Balachandran. In conclusion, in Malaysia cases the judge should apply the maximum evaluation on the evidence at the close of prosecution and make sure there is no reasonable doubt raised at the close of prosecution before the judge can convict the accused if the accused elects silent and offer no evidence after defense is called. With that, thank you everyone. Prepared for Dr. Mukhriz Mat Rus. Prepared by Akmal Safwan, Fatina Lisa and Zaiful Amin.